Welcome to tonight's program, Four Corners Annual Family Law Case Updates. Judge Silberman wanted to introduce the judges and the program itself, so my speech will be limited to the very exciting housekeeping matters only. You will receive your MCLE certificate shortly after the program ends. Please take a moment to complete the survey that is included with your certificate. Sponsors. The Family Law section is sponsored by White Zuckerman, Warsofsky, Luna, Hunt LLP, and Our Family Wizard. White Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. Our Family Wizard is a secure co-parenting platform that supports divorced or separated parents in managing the daily responsibilities of raising children. Specialized features help co-parents organize routines, share files, track expenses and payments, check in at exchanges, send messages, and more, all while thoroughly documenting their activity. For our upcoming programs, we have a new and exciting program planned for February 24th, with the tentative program name being What's New in Department 2, where Judge Pellman will give both BHBA and LACBA members the news and updates in LA County Family Law departments. Please mark your calendars and keep an eye out for a flyer soon to be distributed. Then we have our sections interview series, Direct Examination with Dan and Lauren, has announced a great lineup through the summer with all episodes live on Zoom at 12:30 p.m. Next week, we have February 2nd with Larry Ginsburg, March 2nd with Judge Pellman, April 6th with Ron Brote, May 4th with Dan Jaffe, June 1st with Alexandra Leichter, July 6th with Kendra Thomas and Gina Kang. All prior episodes, including last month's visit with Christina Royce, are available on YouTube. Now onto the program. Judge Silberman, take it away.
Hello, everybody. It's so good to see you all. I know I can't really see you, but I can imagine. And hopefully I'll get to see many of you in person very soon. I certainly hope so. The program we're presenting tonight was conducted for many years under the banner Three Amigos by Judge Robert Schneider, Commissioner James Enman, and Commissioner Bruce Clemens. And I really want to thank them for their many years of service. Many of us attended that program for many years, many of the bench officers, many of the lawyers, and it was just a terrific service to the legal community. And I want to then congratulate them on their much-deserved retirement of the Three Amigos program. I also want to thank the Beverly Hills Bar for asking me to step in and to take over such a storied program. As you can see, we've changed the title and added a judicial officer, and we're now the Four Corners. Now, myself and my co-panelists agreed that with Los Angeles being such a large county, it would be a good idea to have some geographic diversity on the panel. And so joining me tonight, we have from the South Bay, Judge Tim Weiner. And Tim, by the way, is responsible for the terrific PowerPoint you'll be seeing and able to view tonight. So thank you, Judge Tim. We have Commissioner Amir Aharonov from the San Fernando Valley, who's responsible for the Four Corners name, since the panel represents the Four Corners of Los Angeles County. I myself sit in the San Gabriel Valley, and our own Judge Amy Pellman, who abandoned me in Pasadena and now administers our family law discipline and sits in Department 2 down at Mosk. Now, in the years past, there was anywhere between 40 and 60 cases to review during this program. However, thanks to a certain virus whose name shall not cross my lips, there are much fewer cases this year, actually about half as many as usual. Now, the good thing about that is that my colleagues will be open to spending the last half hour or so of our panel answering any questions that you have. So please, if you have any questions during the program, submit them electronically and we'll do our very best to respond to them. So if there is nothing else, we will jump right in and get started. The cases are not in chronological order as far as when the decision was. We tried to group them in a somewhat logical progression. So hopefully we accomplished that. And there may be one or two cases that snuck in just after December 31st that we've included. So give us a little pass on that. All right, so here we go. Next slide, please.
All right, well, good evening, everybody. Like Judge Silberman said, my name is Judge Tim Weiner. I really want to say thank you to the Beverly Hills Bar Association and to my colleagues for inviting me to participate tonight. Our first case, in re marriage of Wang and Zhao, which you have the citation in front of you. So in this case, the minor child of the parties lived primarily out of the United States, lived in China. And in 2018, a court in China issued a custody order as part of a judgment and awarded sole custody of the minor child to respondent. Respondent then attempted to register that judgment in a California court. The petitioner contested the registration of the Chinese court's judgment. And the trial court ended up issuing an order granting the petitioner's request to deny the respondent's efforts to register the Chinese court's judgment in California. And it went up on appeal, and the Court of Appeal concluded that the trial court properly denied that request, not for the reason that was proffered originally, but because the petitioner had properly established that the Chinese court's judgment had been stayed pending his appeal in China. And citing to Family Code Section 3445, which allows a party challenging the registration of a judgment to argue that the judgment should not be registered because it has been vacated, stayed, or modified. And because the Chinese judgment was up on appeal, that argument prevailed. The California court did acknowledge, however, that it could still exercise temporary emergency jurisdiction within the UCC JEA, but the Chinese court was the home court for purposes of the UCC JEA. Next slide, please.
All right, hello everyone. Nice to see you, sort of. Welcome. The Searles v. Archangel case happened to be my case. Ms. Searles was a frequent visitor to the Pasadena courthouse, although I can't say I ever met Mr. Archangel. So Searles filed a request for a civil harassment saying that Mr. Archangel, Michael Archangel, had threatened her by using a, quote, wicked big stick and his own form of martial arts called Tai Kan Kick Yo. And since I can't say the next word, it's synonymous with buttocks and tuchus, and you can draw your conclusions from there. She also included in her request extensive narrative about other threatening conduct of Mr. Archangel. Unfortunately, Ms. Searles was unable to serve Mr. Archangel, and she said that he was homeless and that he was avoiding service. My understanding is that Michael Archangel is a leader of the angelic realm, and he is often depicted with a sword, but I'm guessing that finding an address for him was probably pretty difficult. So Ms. Searles came to court a number of times asking for continuance, for which the court did grant. The court also allowed Ms. Searles to serve Mr. Archangel with the use of the sheriff with a fee waiver. And that was a later issue in the case because she had made a credible threat of violence. She asked initially in one of her requests for continuance and later to serve Mr. Archangel on her social media. What she said was that Mr. Archangel followed her on Facebook, YouTube, and Twitter, and that would be a better place and a more appropriate place to serve him. Ms. Searles actually filed a motion, cited numerous out-of-state cases which allowed service on public media. Those cases discussed service by social media when it was impractical to serve otherwise, or when it would also provide the requisite and practical actual service. After a number of continuances, the court, I finally denied her request for a further continuance, and I noted that if she were threatened again, she could file another civil harassment. And I also noted that under CCP 5276 subsection M, a civil harassment can only be served via personal service. So Ms. Searles appealed, and actually Judge Perlis, the presiding judge of the Court of Appeal, did the opinion in this case. And he said that it was a case of first impression as to whether service could be effectuated by publication through social media. He made a couple of interesting comments that I think might portend the future for us in terms of service on social media. What he said in the decision is that the issue was not whether or not the Superior Court should have allowed alternative service by social media, because if it were, the answer would have been a qualified yes. And that the Court of Appeal was encouraging the legislature and Judicial Council, which has already authorized social media service in certain other areas, to perhaps develop a pilot program to test the efficacy of using these new technologies. This case, however, the question was whether or not it was permitted in civil harassment cases. Essentially, Ms. Searles argued that it should be allowed, and she cited an unpublished district court opinion whereby CCP 413.30 allowed certain alternative service. However, the Court of Appeal said in this particular case, the 413.30 would not be relevant because 413.30 only allows alternative service if the actual statute allows other types of service. However, in our civil harassment, as I stated earlier, in our civil harassment cases, there is no alternate service allowed at this point. Okay, next slide.
Hi, everyone. Not that long ago, I was a participant, so now being on the panel is a different experience, and I appreciate being given the opportunity to be here amongst such esteemed colleagues. So marriage of Sawyer, much like Wang and Zhou that Judge Weiner talked about, is conflict that can occur at the time of registration of an order. And in this case, it was a well-litigated, frankly, extremely litigated Minnesota child support order that resulted in an arrearage finding of about $90,000. And the Child Support Services of Minnesota worked with the Santa Cruz Department of Child Support Services to try to enforce that order here in California. And at that time, they registered and they gave the proper notice for the other party to dispute the registration of the order. Those 20 days lapsed, and ultimately the order was registered. After the order was registered, the party who the arrears were being sought against decided to seek relief from the Santa Cruz court to try to reduce or somehow eliminate some of the arrears. And the trial court, interestingly, dealt with the issue of staying portions of that order versus delving into whether it can modify or otherwise change the orders. In some ways, the trial court understood that it didn't have the authority to modify. So in many ways, it talked about staying portions of the order. And the Court of Appeal said, semantically, the result is the same. That's modifying the order. And that was adamantly indicated as improper. But interestingly, what the Court of Appeals does is it outlines really a roadmap to what practitioners and litigants can do when they're facing a registration of an out-of-court order. And I think that's where this case is interesting, is it indicates that UIFSA, while really talking about full faith and credit between states, does have some relief that's available within those 20 days to try to, in some ways, clarify their arrears or prove to the court that the entire order isn't collectible at this time, or even, interestingly, even establish that the order cannot be registered because the court that issued the order didn't have personal jurisdiction over the party at the time it issued the order, which I think is a very interesting analysis, especially as practitioners, when a client comes and says, child support services is garnishing my wages, what do I do about this? And it's already been registered and they're collecting. What's also interesting in this case is the trial court tried to provide the party equitable relief. While it's not called Jackson credits, the trial court talks about it in terms of equitable relief. Really, it is Jackson credits that the court analyzed and essentially stayed the portion of the order for the time period that the party may have been entitled to Jackson credits. And the Court of Appeals, again, talked about that as being a modification and improper under UIFSA. And while you call it a stay, it's not a stay if the ultimate result is you're not enforcing a properly registered order after the 20 days have lapsed. It would be interesting if he had come to court to challenge the registration within the 20 days, what the Court of Appeals would have done with a court's analysis of a equitable relief for purposes of registering the order, because that 20 days does allow the registering court to analyze the validity of the order and what arrears, what credits may be available to that individual based on what they've paid. And there's a big question mark as to what else the court could do given that limited UIFSA authority. But in this case, because the 20 days lapsed, it really limited the relief available. But I think this case is interesting in showing that those 20 days are critical and there's an opportunity for litigants and counsel to do something before an out-of-state order just becomes immediately collectible as is. Next slide.
Okay, so on its face, this seems to be some really juicy case about some movie stars. But in fact, Brangelina has little, if anything, to do with this decision. It really involves our private judging system and the amount and timing of the disclosures made by private judges when they're appointed to hear these cases outside of our normal judicial system. In this case, it was Judge John Odekirk, an excellent judge who old timers like me may remember from his time in Mosk. I know when I was a lawyer, I litigated with Judge Odekirk, an excellent judge. And interestingly, I thought, he actually officiated at their wedding. And so he had them at the front end and the back end, which is a little unusual. We usually only get them at one or the other. But that created sort of an interesting symmetry in this case, I thought. In any event, when they decided to divorce, there was an original stipulation in 2017 for Judge Odekirk to hear matters, and requisite disclosures were made. And I believe Judge Odekirk disclosed one case in which he was involved with Jolie's lawyers, and somewhere between 6 and 10 matters that he was involved with Pitt's law firm. In other words, he'd heard other cases from them. Now, he also stated, interestingly, in that original disclosure, that he might consider accepting other appointments while the Jolie Pitt matter was still pending. They sort of put them on notice that, well, I may accept other things along the way. Now, the initial appointment ended in 2017, and the party stipulated to extend that appointment to 2018. There were new disclosures at that time about cases Odekirk was hearing for both firms. And then there were further extensions into 2019 and into 2020, when a status judgment was entered and a judgment on custody was entered. Shortly thereafter, in 2020, Pitt filed for a modification of the visitation, and the matter was set for evidentiary hearing in October of 2020. At this point, Jolie had changed lawyers, changed law firms, and she had to ask for some additional disclosures that she believed were involved. And Odekirk was requested to give a statement not only of cases he'd been hearing from Pitt's lawyers, but a statement of his involvement in those cases. And there were more cases that he had been involved in with that same firm. So following his statement, clarifying his involvement with Pitt's firm further, Jolie requested that he recuse himself from the case, and he refused. She filed a verified statement of disqualification, and when it was heard, the court denied it. And she then filed this writ. Now, just so you're all aware, disclosures by private judges or even appointed referees have to be disclosed no later than 5 days after designation, or to matters not known at that time, designation as soon as is practicable. Ultimately, there's an objective reasonability standard when it comes to disqualification of the judge. In other words, how the judge's participation and perceived conflict of interest will look to the average person on the street. So first, Judge Odekirk argued that the disqualification request was not timely, since as part of his initial appointment, he disclosed that he'd had a significant history of serving in cases involving Pitt's lawyers. So he made that initial sort of general disclosure, as well as stating that he can be involved in other things. But that turned out to be not enough, at least as far as the Court of Appeals was concerned. They were concerned that from the time that the judgment entered until the time that Pitt filed his modification request, Judge Odekirk had taken even further work from Pitt's lawyers, and the only reason they ended up getting disclosed was not because he proactively disclosed them, but because Jolie's new lawyers asked him to disclose them. The Court of Appeals was definitely, to me anyway, seemed very concerned that our private judicial system remain as above board as possible. The rules of disclosure with private judges are set up to discourage the appearance that steady customers have an advantage over one-time customers. And the court indicates that the private judges operate in a system where potential conflicts are likely. And so adherence to these very strict disclosure requirements are really vital. Now, the court made it clear that it's not the responsibility of the ADR provider when it comes to timely disclosures. It's ultimately the responsibility of the judge. And although Jolie knew about numerous previous cases involving Oda Kirk and Pitt's lawyers, she didn't know about the most recent ones that occurred post-judgment. And that was enough to disqualify Oda Kirk. So disclosure, 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 and immediate disclosure. And if you're using a private judge and during the pendency of one action, you and or your firm is using her for another action, it would be a good idea for the judge to immediately disclose the expansion of their professional relationship with the firm. Okay, next slide.
All right, this is the MM versus DV case. It's a parentage case, one of my personal favorites. Unfortunately, I would say that this is a fairly unremarkable case. In fact, I wasn't really clear as to why it was published. It does go into the basics of 7612C, and that is, for those of you who don't know, that is the statute that permits more than two parents. So in this case, mother and alleged father are in a relationship. At some point, mother gets involved with TM, and there is, shall we say, an overlap. Mother discovers that she's pregnant, and she tells alleged father MM that he might be the father. She then goes to the doctor soon thereafter, and the doctor opines that MM could not be the father. At least that's what mother tells MM. Of course, reading between the lines, that was obviously based on what mother told doctor, number one, and number two, since, not to get too technical, but since sperm can stay in a woman's body for about 5 days, it's probably impractical for the doctor to really pinpoint the day of conception, especially when we have two partners, but that's another issue, I guess. So after mother told MM that he wasn't the father, he didn't question it, and he made no further efforts to pursue parentage. Instead, mother and TM were together. TM signed a VDOP, and 7 months later, mother and TM married, and they had another child. That other child had a genetic defect, and they were concerned about the first child. So mother contacted MM and asked him to take a DNA test. And lo and behold, MM was the bio father. At that point, MM allowed a few visits, and then she cut him off, deciding that the child would be too confused. After that, MM then filed the parentage action. MM made clear that he didn't want to challenge TM's status as a parent or set aside the VDOP, which he was too late to do anyway, so it was more than 2 years. We should see Family Code 7673. And instead, what he said was, I'm a Kelsey S. dad, and I should be deemed a third parent pursuant to 7612C. For those of you who are unfamiliar with a Kelsey S. father, Kelsey S. is actually an adoption case where the Supreme Court said that it was unconstitutional for a mother to unilaterally terminate an unwed bio father's parental rights if he had promptly come forward to assert his parental responsibilities. In this case, the court did not find MM as a Kelsey S. As the court said, he made no affirmative steps to verify whether or not he was the father. And even after he was determined to be the father, he made no steps to support the child financially or otherwise. Honestly, the analysis should have ended there. But the trial court was an overachiever and said, well, even if MM was a Kelsey S, was a presumed father, this is not an appropriate case for a third parent. And the trial court was correct. The Court of Appeals said, remember, 7612 is a statute that makes clear that, first of all, this is a statute for rare cases, read only in appropriate cases. And also, it is not a case for a parent who wants to develop a relationship with the child. It is a case where it is actually about the child, not the parent. And what the statute says is there should be 3 parents if it would be detrimental to the child for there to only be 2. That's predicated on the assumption that the third potential parent has a pre-existing relationship with the child. That was not true in this case. The only real difference in this case is that it was a Kelsey S allegation, but otherwise it was fairly unremarkable. The only other thing I would say about this case is that the Court of Appeal assumes that the third parent is a presumed parent. That, although that makes logical sense, when I actually looked at the statute for the millionth time, I realized that the statute actually doesn't say that. It doesn't say that the third parent should be presumed. It presumes it, and it's logical, but it actually doesn't say that. So this was not a difficult case to decide on the facts, but it is a nice primer on the 3-parent statute. Next slide.
Okay, so our next case is Noble versus Superior Court. And in the Noble case, the petitioner mother secured a domestic violence restraining order from the state of Utah in late 2019. And fast forwarding to a custody hearing in California, mom notified the California court of the fact that there was a restraining order that had been issued by the state of Utah. The California court, however, did not at that time give an advisement to the parties pursuant to Family Code Section 3044 and the legal presumptions that would have arisen because of that section. Moving forward, the California court awarded joint custody of the parties' 2 minor children without first making the findings required by 3044 to rebut the statutory presumption against an award of sole or joint legal or physical custody to respondent father against whom the restraining order had been issued. And because of that, mom took a writ, and the Court of Appeal went ahead and issued a peremptory writ of mandate directing the family law home court to vacate those custody orders and reconsider custody based on the presumption set forth in Family Code Section 3044. So I think the takeaway from this case, which is probably not surprising to most, is that that the court finding that a party seeking custody has perpetrated domestic violence can be made by any court, not just the court that is hearing the actual custody matter. And that's if in the opinion, the court relies on Family Code Section 3044 subdivision D2. And there's also another case, Ellis versus Lyons, which I don't have on the slide, 2 Cal App 5th 404, standing for the same proposition. So once a judicial body has made that finding that a parent has committed domestic violence, the Family Code Section 3044 presumption will apply, regardless of what court makes that finding. It does not have to be the same court that is hearing the custody matter. Next slide, please.
Okay, continuing in the domestic violence arena, this case needs to be contextualized because this is decided in a pre-coercive control DV statute. And I say this because in a lot of ways, the facts that are asserted by the underlying petitioner of the domestic violence application did outline conduct that would more likely be construed as coercive control. But this Court of Appeals decision doesn't talk about coercive control, but it makes some interesting comments that I think is sort of a nod, wink, wink to coercive control as we know it now in the statute. I think also to contextualize this case, I think that practitioners should look at this and in the context of this often heard objection. Objection, Your Honor, none of those allegations were in the petition. My client does not have has due process rights. We should have known about these allegations so that we can adequately respond. Objection, those are actions that occurred after the filing of the petition. They weren't pled. My client has due process rights. You need to strike it. It's not relevant. These are often heard and often uttered. And in a lot of ways, it sounds like good sense, but FM and MM makes it clear that it's not appropriate. And I think the court in this case, in a sense, bent over backwards to make the point, the Court of Appeals, because the respondent in this case passed away before even issuing this Court of Appeals decision. And the Court of Appeal extended its discretion to make a point because it's a policy decision that they think needed to be articulated in a Court of Appeals position. And in this case, you have wife who sought a restraining order against husband. She alleged physical acts of abuse and also allegations that father secreted the teenage daughter away from her and cut off all contact. I say that not because it was really set out as points for domestic violence, but the Court of Appeal time and time again talks about it. And then I will talk about it in the context of what I see as an interesting dicta point in this case that is also notable. But during the DV proceedings, the Court of Appeal, the trial court decided to continue the domestic violence hearing and even ordered, despite the fact that mother did not have a cross domestic violence application against her, ordered mother to move out of the residence, keeping in mind that mother was requesting that father be moved out of the residence. But the trial court ordered her out of the residence, continued the hearing, and then subsequently, after listening to the testimony, acknowledged that these parties should stay away from each other. But since, lo and behold, they were no longer living together, there's no reason for the restraining order. So the Court of Appeals took it up for a number of reasons, because during that DV application, the trial court itself excluded and did not listen to any additional acts of abuse that the petitioner claimed occurred after the filing of the petition. So the Court of Appeals took issue with the trial court's decision to exclude that evidence and articulates that every trial court has the responsibility to look at the totality of the circumstances. And in a sense, it almost states that at every domestic violence restraining order hearing, what is at issue is domestic violence, not the mere allegations in the petition, but domestic violence that may be perpetrated by the respondent against the petitioner. And that's the totality of circumstances that the court needs to analyze. So that often heard objection now appears to be without foundation and as adamantly ill-advised according to the Court of Appeals. Now turning to the issue of secreting the teenage daughter, again, in a coercive control environment, arguably, the Court of Appeals may have discussed that in the context of coercive control, especially when the daughter was living with the mother, had a relationship with the mother, and then father not only moved her across the state, but then cut off all contact, refused to provide any information regarding the daughter, and would not provide any details as to how she's doing or her whereabouts. What I think is interesting and is dangerous I'll call it dangerous softly, only because in the wrong hands, it may spin out to more issues that people might assert in domestic violence applications, is footnote 5 talks about how cutoff to access of a child may in and of itself be a violation of Domestic Violence Prevention Act. I think the manner in which the court articulated that in note 5 unfortunately allows too much reading into any denial of access may be a basis for an application for domestic violence restraining order. But I think it's important to read it not as a basis to issue a restraining order, maybe an application for a restraining order, and also in the context of these facts where there's extensive history of abuse, and it's clear that the secreting of the child was to punish this petitioner. I think that footnote 5 needs to be read in that context as opposed to giving it a broad reading, which unfortunately footnote 5 reads very broadly. So I call that dangerous dicta of this case, especially in the hands of a domestic violence perpetrator, or alternatively, someone who seeks a domestic violence application on the mere claim that they're being denied access to a minor child. Next slide.
Okay, in re marriage of Brubaker and Strom. So a scenario we see not infrequently, double negative there, is when there is a pendente lite restraining order after hearing issued. The parties go to trial, and the rebuttal of the Family Code Section 3044 is tried at the trial as part of the custodial litigation. Then a year or 2 or 3 years later, the protected party from the restraining order applies for an extension of the restraining order, and much of the evidence that was relevant in the custodial trial when dealing with the alleged rebuttal of 3044 is also relevant evidence in the hearing on the extension of the restraining order. And that is the basic scenario of the facts in Brubaker. Pendente lite, there was a 2-year restraining order issued, and with the judge making remarks on the record that he believed 2 years was sufficient for the parties to complete their dissolution and move on with their lives, hopefully in a more child-focused manner. And sometime after that, there was a request to modify the court's order concerning communication between the parties. And this was heard by a different judicial officer. And she found that there had been violations of the restraining order by the restrained party, and she placed new limitations on the communications between the parties. Shortly thereafter, and I'm not sure exactly how, but the case went to trial, and this third judicial officer found there had been no violations of the restraining order and ruled that 3044 presumption had been overcome, although the restrained party still did not get shared or primary custody. Now, there was a lot of focus on whether there had been any violations of the restraining order. But remember, and we'll stress this again later in the Ashby case, which I'm also going to do, please remember that a finding that there were no violations of the restraining order is relevant evidence, but it's not determinative when it comes to renewal of these restrainings or extensions of these restraining orders. Nonetheless, this appeared to be a major focus of the litigation in Brubaker, so much so that the restrained party filed 2 motions in limine. The focus of the second was as follows. The restrained party asked for all evidence from the last day of his family court trial, the 3044 presumption rebuttal trial, and before to be excluded because the judge in the family law trial had found that there were no acts of domestic abuse since the restraining order was issued, and they claimed that the issue had already been adjudicated as part of the family law trial while determining if the 3044 presumption had been rebutted. In other words, issue preclusion. And the trial court believed that since the family court had made its ruling, the focus of the inquiry now was what had happened only since the completion of the family law trial. The trial court reasoned that when the initial restraining order was issued, the judge found that 2 years was sufficient, so the inquiry should concern itself only with what has happened since. Therefore, in this case, the protected party did not put on evidence underlying the original restraining order or evidence considered by the family law trial court in finding that the restraining order had not been violated. Now remember, the law here, a restraining order can be extended without a showing of further abuse since the issuance of the original order. Now, if that standard were different, think what it would mean. It would mean that the protected party would have to demonstrate that the initial order had proved ineffectual in halting the restrained party's conduct just to obtain an extension of that ineffectual order. There's an anomaly for you. Instead, a court should renew a DV restraining order when the court finds the probability of future abuse is sufficient that a reasonable person in the same circumstances would have a reasonable apprehension that such abuse will occur unless the court issues a protective order. And as I frequently have to state on the record when hearing these renewal cases, the restrained party is not permitted to challenge the truth of the evidence and findings underlying the initial order. The issue preclusion that the trial court allowed was improper because the issue the family court heard at the custodial trial was whether the restrained party rebutted the presumption under Family Code Section 3044 and deciding on a custodial plan in the best interests of the minors. The issue at the restraining order extension hearing was whether the protected party had a reasonable fear of future abuse. Very different issues, and in order for issue preclusion to be in effect, the issues have to be the same. Now, that's not to say that the findings in the earlier hearing were not relevant. It's just that they did not resolve the inquiry at the later hearing. Additionally, the finding in the original restraining order case, where the judge stated that he believed that a 2-year order would be sufficient, should not have barred presentation of evidence prior to the original restraining order to prove reasonable apprehension of future abuse. I think in this case, and in Ashby, which we'll do in a little while, I think the court's making themselves pretty clear. They want the trial court to have a broad spectrum of evidence available so that they may make a ruling on whether there's reasonable apprehension. That's a difficult decision. In order to find out whether someone's reasonably apprehensive, they got to know what happened to begin with, how it happened, what happened after. The Court of Appeals is not advocating relitigating the restraining order, but they clearly believe that examination of the facts that led to the initial restraining order are relevant and admissible when determining whether there's been reasonable apprehension for the purpose of extending a restraining order. Next slide.
I knew that was going to happen at least one time. This is the JH versus GH case. And to me, this was a really interesting case insofar as the intersection of the dependency court orders and the family court, and the different philosophies that we have regarding domestic violence. So in this case, the parties got involved with the dependency court in 2018 after there were some very serious allegations of domestic violence, some of which include father physically abusing and choking mother until she lost consciousness, urinating on herself, and this was also in front of their 12-year-old daughter, who called 911 on behalf of mother. Other incidents included father bruising son's ribs after roughly grabbing him, attempting to suffocate the mother, allegations of sexual abuse, name calling, threatening to leave her penniless and homeless, and urinating on her while she slept in the bed with the child. The juvenile court took jurisdiction, and during the pendency of the dependency case, the mother filed a dissolution in family court. Apparently, or what I would surmise, is that father was ordered to complete, and he did complete, a 52-week domestic violence class, parenting class, individual counseling. And he also later alleged that he changed his use of alcohol, which I never quite figured out what that meant. When the juvenile court terminated the case with what most people call an executor order, which of course I hate that term because it does not does not connote a final order, with a final juvenile custody order, the parties went to mediation and they agreed to joint legal custody, and father had supervised visits. Apparently, the dependency court opined that the supervised visits were because the children did not feel comfortable with the father still, but the juvenile court hoped that with more therapeutic interventions and supervised visits, that the parties would move towards less restrictive visits. Sometime thereafter, about a year after, father filed an RFO asking for family therapy, and soon thereafter, mother filed the restraining order, which is the issue in this case. In her request, she asked that the children be included in the restraining order. She reiterated the abuse that went on during the marriage, and also that father had unilaterally withdrawn the children from school and left them without a comparable school. There was an extensive evidentiary hearing. Mother testified that the children had been adversely affected by the domestic violence, that the daughter was afraid, that she was clingy, and that she was overprotective to mother, and that the son had developed a stutter, and that he had a nervous tic, and that he often wet his bed. Father testified that nothing had happened since 2018, which was about 18 months before the hearing. He said he was remorseful and that he was committed to a better relationship with him and his children. He also denied some of the allegations. Here's where it gets kind of interesting. The parties stipulated that the jurisdiction disposition report from the dependency hearing would be in evidence, and the social worker from the case also testified. The social worker opined that the mother might be coaching the children, and that when she had observed the children early on in the case, they didn't seem particularly afraid of the father. She also indicated that she was concerned that the mother was emotionally abusing them by over-engaging them in trauma services, although there was really nothing else to explain what she meant by that. The court issued a 2-year restraining order, but did not include the children. It explained that it based its decision on basically 2 reasons. One, that the court felt that the father did not presently pose a risk to the children, and that there had been significant period of separation between the father and the children, and that the court wanted to begin repairing the relationship and felt that that would be in the best interest of the children. Mother appealed and claimed that the court erred, not including the children as the protected party. The question in this case, which was a novel question, was what is the correct standard for including children as protected parties? The mother claimed that 6340 provides for inclusion of the children as members of a household based on a finding of good cause and the totality of the circumstances. Father, on the other hand, claimed that the court should, yes, consider the totality of the circumstances, but that 6340 should only include the children as protected parties if the court found that the failure to do so would jeopardize the children's safety. The Court of Appeal reviewed this on a de novo and found that 6340 only requires that a court consider the safety of the petitioner and the children for whom the orders are being sought. Thus, while a showing of potential jeopardy to the safety of the children might be sufficient for including them, it is not a prerequisite for doing so. Mother also argued that the trial court erred by requiring a showing of probability or likelihood of future abuse. And the Court of Appeal said, no, the trial court actually used 2 different reasons, not just that they didn't believe there was a future threat, but also that it was in the best interest to repair the relationship. Mother also claimed that, that the evidence was overwhelming and that by not including the children, that it was an abuse of discretion. Again, the Court of Appeal disagreed and said that the court had considered both sides. It had considered the evidence of the abuse to the children. It had considered father's contrition and the programs, and that the trial court's decision would not be disturbed as it was not outside the bounds of reason. There's a lot I could say about this case. First of all, trial courts have a lot of discretion. And that is loud and clear from this case, and that their discretion will not be disturbed as long as they make appropriate findings for the most part. I found it interesting that 3044 was never discussed. Certainly it's an issue du jour. Think the Noble case, and after this, the KL versus RH case. On a completely different issue, I found it interesting that the dependency court report was brought into evidence. Was it sealed? It's confidential. How did, in fact, the parties even get it into evidence? Did they take the, requisite steps that they're supposed to by filing a JV 570? I kind of doubt it. Did the trial court or the Court of Appeal even understand the significance of the Juris Dispo report, which is a social study report, which is used to help prove the allegations? We never actually knew what allegations were actually sustained. We can surmise which ones, but it was never discussed. Then how about the credibility of the social worker. Was she involved early on the case? Was she involved later on the case? On what basis was she making her conclusory statements? And even so, completing completing a parenting class, completing a DV class, that certainly shows something, but there was no discussion as to whether or not father actually learned something from those classes or he just completed them. At any rate, to me, this highlights that we have two different court systems, which are not just different, but also really lack understanding of each other. It's my hope that hopefully in the future that will change, but we'll see. Stay tuned. Next case.
All right, KLNRH, where Judge Pellman talks about the discretion of the court. KLNRH talks about the limitation of that discretion, but also if the court's going to exercise its discretion, it needs to explain itself and why it exercises that discretion. And this is a case involving mutual requests for domestic violence restraining orders and the implication of Family Code Section 6305 and the trial court's responsibility to analyze 6305 before it even issues mutual restraining orders. This is a case where mother and father have a long history of domestic violence. Mother talks about several incidents of physical, violent domestic violence, and father also seeks a domestic violence restraining order, mostly based on verbal abuse, allegations of threats of violence by mother, which, though interestingly, he admits he didn't take them on as actual threats and wasn't particularly frightened by them. But nonetheless, he filed a DV restraining order. I say this because in a lot of ways, this case should be contextualized in when you talk about cross requests for restraining orders, which often might be filed due to tactical decisions or litigation decisions, and also taking into account, first and foremost, the application of 3044 and what that might mean to a litigant. And I think this case, in highlighting 6305, it should be a warning sign to individuals who might be filing DV requests in order to obtain, whether it's not leverage, it's to equalize, because that, I think, is the part that KLNRH really talks about, is analyzing whether parties seeking DV restraining orders really are equal or not. And in analyzing by the trial court is bound to actually analyze whether the acts of abuse are equal, not just that one party perpetrated acts of abuse against the other, but actually weighing them and seeing who was the primary aggressor. And I think that's a warning to a party who might be seeking a restraining order and has much more minor allegations of domestic violence, but thinks, I too am a victim of domestic violence. I too am entitled to a restraining order, and that the trial court is going to say, as this court did, the trial court in this court said that it's going to analyze each application for a restraining order separately, essentially as two separate hearings, and decide that both parties carried the burdens of proof, and both parties therefore get a restraining order. The Court of Appeals says, not so fast. The Court of Appeals does something very interesting. In this case, it not only goes through the steps of applying 6305 and telling the trial court that it failed in its responsibility to look at 6305, it actually goes through the process of dismantling father's application for a restraining order and indicating that the court abused its discretion in even giving him a restraining order. I think that's interesting because 6305 is really triggered if the court is going to consider mutual orders. 6305 doesn't apply unless the court is weighing that the restrainable conduct has existed both ways. And in this case, the Court of Appeals said 6305 wouldn't have been triggered because father failed in his burden of proof and the trial court abused its discretion. But even if there was a 6305 implication, if you weighed the parties' conducts, clearly father is the primary aggressor and only mother should have received a restraining order. I think along the lines of cases for domestic violence that have come out this last year, which really focuses on the import of 3044. This case too also talks about not, in a sense, I think it intimates that the restraining order process is not an opportunity for a court to sidestep its 3044 analysis. And in some situations, while there might be mutual acts of domestic violence, the courts shouldn't try to find mutual orders in order to not deal with the 3044 presumption. I think that's intimated in this appeals decision, and the Court of Appeals talks about 3044 extensively. I think the other interesting part in this case is that the Court of Appeals talks about how this case specifically was involved in dependency proceedings before the court issued its orders, and talked about what the trial court should do once that juvenile custody order does come back. And I think what's very interesting is it orders the trial court to consider 3044 once it receives the juvenile custody order. And I think, to me, this raised a lot of questions, especially since coming from a dependency assignment prior and understanding the importance and the import of Welfare and Institutions Code Section 302D when you talk about modifications of any juvenile custody orders. It's also understood in the juvenile dependency world that 3044 doesn't apply. The juvenile dependency judge is not bound by 3044. But it's interesting in this case that the Court of Appeals says, quote, and it's right before its final disposition, quote, after the dependency matter is resolved, the trial court shall consider any new requests for orders filed by the parties regarding legal and physical custody of ZL pursuant to Family Code Section 3044. I think it's interesting because it essentially says that 3044 suddenly makes an appearance. And when does it make that appearance? When any party seeks a modification of the juvenile custody order pursuant to Welfare and Institutions Code Section 302D. And as we know, even in cases of domestic violence, the juvenile custody order often has joint legal custody, for instance, or even joint physical custody, despite allegations of domestic violence. So whether inadvertently or advertently, the Court of Appeals says 3044 shall rise at those modification proceedings. I think it'll be interesting to see what the ramifications of KL and RH are on that question, because frankly, I think it's an open question to a lot of parties, but also judicial officers. What do we do with 3044 when we face a juvenile custody order that, had the same allegations been made in family court, it would not have resulted in the same juvenile custody orders, but now family court is bound by 302D of the Welfare and Institutions Code. So I think KL and RH is interesting in so many ways, but from a practitioner standpoint, it really is about considering, before you file that cross request for a restraining order, how strong are your claims relative to the other party's claims? Do you really want to start a two-front trial as opposed to focusing on the credibility or the allegations of the other party? Do you really want your client's allegations weighed toe-to-toe with the other party's allegations? And what impact does it have on your client's credibility when, in the face of very extreme allegations of abuse, they might be talking about having expletives thrown at them, as it was in this case, or that offhandedly a party said, I'm going to kill you, and though that individual laughed it off. I think practitioners should look at not just the tactical decisions, but ultimately the code provides the trial court an obligation to sidestep those issues and really gets to the heart of it, of who is the primary aggressor if it is inclined to issue mutual orders, and no matter what, apply 3044. Next slide.
Okay, continuing with our dominant theme of domestic violence this evening. This is in re marriage of Carlisle. And this case has to do with the court's jurisdiction to renew a restraining order after hearing. So what happened in this case was that the wife secured initially a 2-year restraining order. There was a domestic violence restraining order hearing. The court granted the request and set a 2-year time limit for the restraining order. And the husband, in a timely manner, filed an appeal challenging the issuance of that restraining order. And while that appeal was still pending, and I think it was about a month before the restraining order was set to expire, the wife timely filed a request to renew that restraining order. And the husband objected. After a hearing, the trial court did grant the wife's request to renew the restraining order and renewed the order for 5 years. Now, as you know, upon a request for renewal, the court doesn't have quite the discretion it has at the time of issuance. The court can either deny that request, it can renew the order and extend it for 5 years, or the court can make it a permanent order. In this case, the court chose to extend the domestic violence restraining order for 5 years. And the husband appealed and argued that the trial court simply lacked jurisdiction to renew that restraining order because the appeal from the granting of the original order was still pending and had not yet been decided. And the Court of Appeal did not agree with husband. It held that where there was an injunction of a limited duration, which was the case here, and that was appealed, the trial court still maintained power to extend the injunction pending the disposition of the original appeal. And this is the catch: if doing so would serve the ends of justice. So the takeaway here is that the trial court does have the authority to renew a restraining order, even if the initial order is still on appeal, if doing so would serve the ends of justice. And in this case, the Court of Appeal stated that the trial court, having determined that wife had satisfied her burden in seeking renewal of the restraining order, necessarily concluded that renewing the order would serve the ends of justice. Otherwise, it would not have renewed the restraining order. So, the practical tip here would be to just make sure that finding, request that finding be included if your client is seeking to renew the order. But I think it's a very straightforward case, but an interesting one. Next case, please.
Okay, in the interest of time, I'm going to move pretty quickly through Ashby. It's another case centering around litigation concerning the renewal of a DV restraining order. It was ultimately decided in the Court of Appeals. It was appealed due to, it was alleged that there was a lack of evidence the trial court had. And it was, the decision was affirmed, but there were procedural difficulties with the claim. So I'm not going to go into all of that. I will say that if you, like many of us, are having trouble with a mother-in-law, read this case, because you may feel better about your mother-in-law after reading this case. The important point here is that when the wife filed for the renewal, the extension of the restraining order, she was asked specifically by the court as to the reasons she wanted the extension. And she stated exactly why she was still afraid. She cited both past behavior and current behavior. She cited the fact that it was clear that her ex-husband owned over 100 firearms. She shared several violations of the restraining order. He tried to counter, obviously, with evidence saying, no, I've learned my lesson. I'm so good. I really haven't done anything. I completed a 52-week batterers program. But what's clear here, and I think important for either a court to inquire or for people representing clients who are trying, is ask specifically, why is it that you're afraid? Because that's the key inquiry here. And all of the things we talked about, I talked about in Brubaker before, about what's necessary evidentiary-wise and not what the legal standard is, are all reiterated in Ashby. And again, I think the fact that they published it, they just want to make that really, really clear about what the standards are here. A trial court should renew a protective order if and only if it finds by a preponderance of evidence that the protected party entertains a reasonable apprehension of future abuse. So there should be no misunderstanding. This does not mean that the court must find it is more likely than not future abuse will occur if the protective order is not renewed. It only means the evidence demonstrates it is more probable than not that there's a sufficient risk of future abuse to find the protected party's apprehension is genuine and reasonable. Consequently, the trial court should consider the evidence and findings on which the initial order was based in appraising the risk of future abuse should the existing order expire. The truth of the evidence and findings underlying the initial order should not be challenged. Now, the initial order is not determinative, but it is relevant and is not going to be relitigated. Also relevant is when the parties have moved on with their lives in current situation. What happened in the past? What happened in the middle? What's likely to happen in the future? All of those things, again, I think the Court of Appeals realizes for a trial court to make these findings, they need a lot of information. And I think they're expanding and expanding the kind of information that's relative so that the court can make this difficult call. All right, next slide.
Okay, so this is somewhat of a surprising case. So this case involves non-CLETS orders, which I think in Los Angeles, we're pretty well settled that we don't do them and that the law does not provide for them. But perhaps in other parts of California, that's not true. So in this case, the wife filed for a disso and the parties stipulated to the appointment of a temporary judge to try their matter until the final determination. During the pendency of the evidentiary hearing and of the hearing to try the disso, husband filed the DVRO. First, he filed it with the temporary judge, and then he filed it with the Superior Court. He made numerous claims. He claimed that wife harassed him with emails, that she intentionally bought a house near him so that she could spy on him. She made false police reports. She followed his girlfriend who lived with him in an aggressive manner on the freeway. And then also my personal favorite, that she delivered a book entitled to his girlfriend, entitled Women Who Love Psychopaths, Inside the Relationship of Inevitable Harm with Psychopaths, Sociopaths, and Narcissists. Now, he determined that it was the ex-wife who had delivered this interesting book because she would often leave this same book on his bedside table when they were married. So at any rate, the temporary judge did not issue a restraining order, but issued a non-CLETS order. Interestingly, wife appealed that. Not husband, but wife. And first she said that the temporary judge lacked jurisdiction to issue the order because it was ancillary to the action. And the Court of Appeals said, no, it's not a different action. The court said it's offspring or the direct progeny of the marital dissolution action, which I think is pretty obvious, and that it is akin to an RFO or a motion in a dissolution. Then she said that the temporary judge abused her discretion by issuing a non-CLETS order and that the entire order should be vacated. Unfortunately for her, the Court of Appeals said, well, yes, the temporary judge abused her discretion by issuing a non-CLETS, but no, the remedy was not to vacate the whole order, but to remand it back to the temporary judge so she could actually issue a regular restraining order against the wife. Finally, the wife complained that the girlfriend should not have been included in the restraining order and that she shouldn't have been permitted to testify. And again, the Court of Appeals said no, she was a member of husband's household and she could be a protected person. So probably the wife should have left well enough alone. But on the other hand, it just emphasizes for us how important it is not to either ask for non-CLETS and certainly not for judges to issue them. All right, next slide. So this is a Hague case, and Department 2 has the purview to do the Hague cases. So, and they're very interesting. They often involve, they involve international custody disputes, as does this one. This was a custody dispute between an American mother and a Chilean father. Mother alleged that father subjected her to various acts of domestic violence, physical violence, emotional abuse, and did so in front of the children. The violence was occasioned by excessive alcohol consumption by the father and had increased over the years. The parties had met at UC Davis Law School, where the father was getting an advanced legal degree. He was already a lawyer in Chile, and mother was getting her law degree. After they married, they had a few children, and about 10 years later, they moved back, or they moved to Chile, where father was practicing law and mother was also practicing remotely law. The incidence of domestic violence increased in Chile, and mother testified that on numerous occasions, father had drank excessively. He had engaged in physical and emotional abuse, including pushing her from a car, and an incident on Chilean Independence Day, where the child had actually gotten involved and father had been driving erratically. A couple of years later, the parties came back to California for a 2-week vacation, where mother alleged that father had again used alcohol excessively and again become verbally and physically abusive, including kicking mother in front of the children, and spitting on her. At some point after the vacation, father went back to Chile and he texted mother, "Don't bother coming back, there's nothing left for us." At that point, mother, who was still in California, petitioned for a dissolution and also filed a restraining order in California. Father came back for a visit. Mother allowed the visit, but mother's mother insisted, the mother-in-law, that father sign an agreement agreeing not to drink alcohol while he had custody of the children, which apparently he violated, didn't disagree that he violated. He simply said later that he didn't really read the agreement and that he felt under pressure from his mother-in-law. He then went back to Chile and he filed a Hague. This case is interesting because it does illustrate the complexity of Hagues and the varying burdens of proof that you really need to be aware of in a Hague case. Just a quick primer, Hague cases are not custody hearings. The purpose of a Hague Convention case is to return an abducted child to their habitual place of residence, so that that jurisdiction can decide what is in the child's best interest for custody. So in a sense, a Hague case is really akin to a jurisdiction selection case. A Hague petition has to prove, once you file a Hague petition, which by the way has to be filed within a year of the wrongful removal or retention, the Hague petition must show by preponderance of the evidence the wrongful removal, and essentially the petitioner must show that the petitioner has the right of custody and which country is the child's habitual residence. This was not an issue in this case since the children had been living for a number of years in Chile. What happens is that the burden then shifts to the other parent, who then has to prove an exception if there is one. Most exceptions have to be proven by preponderance of the evidence, except the most common one that is asserted, which is that there would be grave risk of physical or psychological harm if the child were to be returned to the habitual place of residence. So in this case, the mother showed that through the evidence that the children would be at grave risk of psychological and physical harm. And she proved it by clear and convincing evidence. But even with the grave risk exception, there's also an exception to the exception. And the exception to the exception is that the petitioner can show that ameliorative measures have been taken that would in fact reduce the grave risk of harm. This is a judicial exception. So in this case, the father said, well, there may be grave risk of harm, but Chile has domestic violence statutes, and it does protect victims of domestic violence. And the court said, not really good enough. The father did not accept responsibility for the fact that he was a perpetrator of domestic violence, number one, and he certainly did not acknowledge his excessive drinking. And so therefore the court said, no, the exception to the exception does not apply, and the mother wins. Next slide.
Okay, we're running short on time. I asked my co-panelists to move things along as quickly as possible. And Kelp or Kelpie, this was a 13-year marriage where the husband worked for Ernst & Young as a non-partner employee during the marriage. As such, he acquired benefits under a qualified defined benefit retirement plan and a 401k. And post-separation, he was offered an equity partnership in the firm. As a partner, he was offered deferred compensation through a couple of plans that were not offered to non-partner employees. A few years later, husband had a heart attack and he was asked to withdraw as a partner, for which he received a lump sum payment pursuant to the deferred compensation plan he accrued as a partner in the firm. Now, the wife argued that the deferred compensation payout was community property, stating that the partnership rights accrued during the marriage because of an expectation of advancing to partnership during that time, and also analogizing to her rights to receive modifications to benefits accrued during the marriage. So the court distinguished this claim from the claims in Lehman and a lot of the cases in that line, where an enhancement of a benefit which the community has an interest in, such as if the community has an interest in the pension and after separation, the pension changes the rules for the age you can claim it, for the years of service, for the final salary, and these retirement incentives are enhancement of something that the community is entitled to a benefit from, then they're entitled to that. And they leaned heavily on our good old Brown rule, which defines the limits, the community's interest in deferred compensation. And here, the new benefits were only accessible upon husband's post-separation entry into the partnership plan. They were not derivative benefits from his years of pre-partnership employment. So if the contractual right to a benefit is not acquired until after separation, okay, and it's a wholly new right, it's not a derivative right, then the benefit is separate property. Next slide.
Okay, moving into the more Marsden area and property characterization. This is in re marriage of Nevai and Clemuns. I believe I'm pronouncing that correctly. Now, in this case, prior to marriage, wife had a cabin in Lake Tahoe, and the parties stipulated to certain facts about what the property cost when wife purchased it. And it was also stipulated that during the marriage, about $1,800 per month was spent to maintain the property, which importantly included an escrow tax account payment. And that was all paid from a community account. So at the trial, there was a forensic expert, and the expert testified that about $100,000 in the mortgage principal and $7,000 in improvements to the property were made using community funds. But what was really at issue is that the expert also calculated about $176,000 in reimbursement to the community for the mortgage interest and the property taxes, because the expert said those were also paid with community funds. And then the trial court adopted that and ordered reimbursement for the community's payment of mortgage interest and for the community's payment of property taxes of the cabin. Wife appealed, and the Court of Appeal held that expenditures for interest and taxes should not have been included when calculating the community's interest in the separate property. And instead, the expenditures for the interest and taxes should have been considered simply as expenses that were incurred to maintain the investment. And because they were not assets or debts of the community, they couldn't or should not have been considered by the court at dissolution. So the holding was simply that the trial court erred when ordering reimbursement for the community's payment of that mortgage and interest, since the tax and interest payments didn't fall within the Moore Marsden rules. Next case, please.
All right, Ramsey and Holmes, a juicy case of 7 pages. It's one of my favorites from 2021. This could be called more specifically as a Moore Marsden case because it does involve a Moore Marsden case, but the holding is very interesting because the way it's written by the Court of Appeals, it is almost expands the discussion to community property in general. And I'll briefly talk about the facts. This is an LA case. There was a trial. The parties agreed that that certain property was separate property, but that it would be subject to Amor Marsden. At trial, the separate property owner husband did not really cooperate in providing the details in order to establish what that Amor Marsden calculation. Wife attempted to, but missed a few of the essential elements. Ultimately, the court did what it could to cobble together what information it had, and then the matter was appealed, and the Court of Appeals found a party can't sit on a claim that the other party has the burden of proof to establish a Amor Marsden claim. Specifically, the holding is more expansive, and I think is interesting, is that it says, quote, "We hold that where it is undisputed and there is a community property interest in real property, it is the obligation of both spouses to ensure that the family court has the information necessary to determine that interest, no matter which spouse brought the dissolution action. If the spouses fail to do so, the family court must direct them to furnish the missing information, reopening the case if necessary," end quote. In a lot of ways, I almost feel like on the community property front, Ramsey and Holmes does to community property characterization and disposition litigation what Feldman may have done for disclosures. Because now in the right hands, Ramsey and Holmes could obligate both spouses to put all of their cards out on the table and ensure that the trial court has all of the details. There may be disputes about things like fair market value or how to calculate it, but the details that, especially in a Amor Marsden calculation, that need to be established, now both parties have that obligation with neither party carrying the burden of proof. I think in a lot of ways that's commonsensical, but I think what's interesting is that this court obligates the trial court to take a much more active role in directing the evidence at trial, essentially saying that a trial court either can take one of two approaches. You could take the evidence as it's presented, and if it's insufficient, then you can't render a ruling on that asset or that reimbursement claim or that community property interest. And unfortunately, there will be another trial on the reserved issues. Or alternatively, you need to foresee the deficiencies, force the parties to comply pursuant to Ramsey and Holmes, provide the evidence so that you can ultimately adjudicate it. I think in a lot of ways, the Court of Appeals even relies on certain snippets that Feldman relied on, specifically talking about favoring the reduction of the adversarial nature of the proceedings and why documents need to be shared and introduced to each other. And ultimately, both parties under certain circumstances need to ensure that that evidence comes to the trial court to make its decision. I think it's a juicy 7 pages, well worth the read. Next slide.
Okay, this is in re marriage of Kahan and Diamond. We could probably spend a long time talking about this case. There is a lot going on in this case, but in the interest of time, I'm going to go through it pretty quickly. So in this matter, the parties were married for 17 years and they had 3 kids together. They divorced in 2014 and there was a stipulated judgment. And at that time, the parties stipulated as to the husband's gross annual income and a child support and spousal support order was made. Now, in 2017, husband filed a request to modify the awards, and they were changed to reduce both payments. So then we get to 2019, where the fun starts. So husband filed a second request to modify the awards, and he alleged 3 material changes in circumstances to justify his request. So the first was that the party's second child had aged out of child support. The second was that his income had decreased. And the third was that wife had failed to make good faith efforts to becoming self-sufficient. So she did not heed the Gavron warning. The trial court opined that the second child aging out from support was insufficient by itself to warrant a reduction, but it didn't expressly go through each of the 4320 factors in making its order. And of course, this is a post-judgment, so it's just like when you set a permanent support order, you have to go through those 4320 factors. And interestingly enough, the Court of Appeal looked at the record. The trial court indicated that it had considered the entire record and considered all of the evidence presented. The Court of Appeal held that the trial court is not required to expressly identify each 4320 factor in writing or on the record and how it weighed each one. And then there's a new paragraph, and it goes on to say that the court felt compelled to make a final observation that trial courts may consider it a better practice to make findings as to each section 4320 factor in writing or on the record. So you don't have to do it, but you should do it. And it went on just to explain how the express findings are going to provide a better record on appeal, and it'll help advise the parties so they know that the statute had been followed. I think it's also important to note that the failure of the court to make express findings could become relevant if the judgment doesn't have a lot of insight. In other words, if the record is silent, the Court of Appeal may not be so kind to the trial court moving forward. Again, there's a lot of other stuff going on in this case, but to me, the big takeaway was, even though the Court of Appeal said that trial courts are not required to expressly identify each 4320 factor, it seems like they're kind of telling us the opposite, and that we should be identifying each 4320 factor. And I certainly think that is the best practice. Next case, please.
Okay, this is marriage of Mar and Strawn. And this case answers the question, can a supporting spouse deduct monies paid to support the couple's adult child while the child is in college, thereby reducing their income available for spousal support and resulting in less spousal support to the other spouse? Now, there's been a split in this for the Epstein case, which is a Supreme Court case from the 70s, and up through the Paul case in the 80s, all said, yes, they can do that. And then around 2000 or so, marriage of Cerna said, well, wait a minute. That's sort of ordering de facto adult child support, and the court can't extend its jurisdiction over child support except when authorized by the code. And so the Court of Appeal sort of settles this conflict by saying, well, yes, you can, unless it's unreasonable, and then you can't. I'm not going to go through all the facts of this case in the interest of time. Father was a less than sympathetic litigant. I'll give him that. But in the end, what the court basically did is they turned their ruling on a policy call. They didn't overrule Cerna and suddenly authorize de facto adult child support. Instead, they built a distinction for these college expenses by stating that California maintains so many institutions of high learning at public expense that this demonstrates that the public policy of the state is that everybody, if possible, should have a college education. And so when reviewing the 4320 factors, a court can consider a supporting spouse's contributions to the children's college expenses if it is reasonable to do so. And they suggest 10 factors the court should consider when making this call. It's so kind of the Court of Appeals to give us a few more factors to consider when reviewing 4320. And among them, I'm not going to go through them all, but the amount of money that's expended, the ability to pay the expenses, the aptitude of the child. I guess if your child's not so smart, maybe it's unreasonable to send them to college. The child's financial resources. So if your kid's got a $50,000 trust coming in, probably be unreasonable. The child's ability to earn income, get that kid out and working. The availability of financial aid, including loans, and the relationship of the education to the child's goals, I guess if they're planning on being, I don't know, a doctor and they want to go to college to study philosophy, maybe it's not directly related. I don't know. And there are a few other these kind of very esoteric examples, which you can all read about. Some of them are rather esoteric, but again, if you have a case like this, there are these 10 new factors to throw in under 4320. So I really believe the Court of Appeals is giving the go-ahead for the trial court to make a discretionary call, which would not be set aside on appeal, no matter which way the court goes, if the ruling is deemed reasonable based on those factors outlined. But I believe they are far more disposed to rule in favor of considering the expenditures unless they're really unreasonable based upon the policy reasons they outline. Next.
Harvey, I forgive me for interrupting. It looks like we lost the text of this slide, so I'm going to give the citation for this case. It's 63 Cal App 5th 356. In re marriage of Maher and Strawn, STRAWN, 63 Cal App 5th 356.
Thanks, Tim.
All right. Pletcher is a temporary spousal support case that deals with the court analyzing a representative sample of income under marriage of Riddle, and where the trial court in this case, while it followed the age-old tried and true method of looking at the last 12 months, in this case, that in fact proved to be an unrepresentative sampling, and the Court of Appeals said that wasn't a proper use of its discretion. I think that for purposes of defining what is unrepresentative, Pletcher is I think clarifies further the discussion from previous marriage of Riddle progeny. But I think that finally there's some more straightforward answers as to what is an appropriate business loss or expense, specifically that one-time expenses would not qualify, and then finally applying the DeLuca standard to business expenses in this context so that it gives a little bit more clarity. I think the interesting point in this case, which I think forensic accountants should take note of, is that in this case, the Court of Appeals talked about how two forensic accountants gave, surprise, surprise, wildly different approaches to assessing the spousal support. And it talked about the court essentially having to work with what it had. And the Court of Appeals says, not so fast, because spousal support determination is an equitable consideration. The trial court has the ability, in a sense, to deconstruct the forensic reports. And in this case, should have been given permission to look at those forensic reports. And while one party tried to give a forensic analysis of over 10 years to include also the recession, the Court of Appeals said, well, the trial court could have looked at 5 years if it wanted to, despite the fact that the reports didn't provide those opinions. I think that's interesting, that it invites the trial court to look beyond just the basic one side or the other forensic reports and really delve into it and use its equitable authority to establish a representative sampling and to use the reports effectively, as opposed to thinking of them as you either have to choose one or the other. Next slide. Okay,
People versus Bearfield. I'm not sure how often this comes up, but I found it to be sort of an interesting case. So the husband and wife were married in 2004. And in 2017, the husband and wife had been long separated. As a matter of fact, the husband had filed dissolution papers in 2009, but the divorce was not final at the time of trial in 2018 due to filing difficulties. I don't know what those difficulties were, but they must have been doozies. But anyway, so the wife is an estranged wife, but they are still legally married. In 2017, husband is charged with corporal injury, assault with a deadly weapon, and false imprisonment arising out of an attack against his ex-girlfriend, not the wife. So husband is long separated from, but still legally married to wife at the time of his trial for his attack on the ex-girlfriend. The prosecutor moves to admit the husband's prior uncharged acts of domestic violence against the wife. And the wife asserts the marital privilege to not testify against the husband. Now, the trial court relies on well-established California law that uses the date of separation as the demarcation for determining a divorcing spouse's community property and separate property. And using that line of reasoning, the court determined that the right to the marital privilege also ended when the parties separated, even though they were still legally married. And the Court of Appeal said that is just wrong, that the trial court erred when it denied wife's assertion of the marital privilege. And the Court of Appeal made it very clear that the marital privilege is available until the marriage is dissolved by final judgment of dissolution. There is no exception to the marital privilege for non-viable marriages like were present here. So again, I don't know how often this is going to come up, but I found it to be sort of an interesting fact pattern. Next case, please.
Okay, I've been given the next two cases, which are the malpractice cases, probably because I'm the only one that might still have the statute of limitations running on my family law experience, or tolling for that case, based on Knapp and Ginsburg, as we've learned. But I'll start with Knapp and Ginsburg, and definitely this is that oi case of whether you regret that you've been doing premarital agreements, or it makes you feel good that you got out of that game a long time ago, which a lot of family law practitioners decide to do. But Knapp and Ginsburg deals with 1615's requirement of a separate writing when a party does not have legal representation. And what's interesting about it is it defines unequivocally that absent that compliance with 1615, an agreement is void, not voidable, which is interesting because it even talks about an individual who may seek to enforce it, who may have been the party who didn't have counsel. It could still be voided because it's void, not voidable. And it also begs the question as to what if both parties stipulate to enforce it and there is no compliance with 1615? Is it void, or can it be stipulated to as enforceable? A lot of questions with Knapp and Ginsburg, but what's clear is better check your boilerplate language, because the Court of Appeals excoriates the counsel for its boilerplate language, and reliance on boilerplate had no bearing for the Court of Appeals, and in fact did not weigh well in favor of the claims for enforceability or lack of malpractice. I think what's interesting beyond the void and voidable is that even in cases such as this, where there's a long history extending beyond the signing of the premarital agreement, it's important to understand how continued representation tolls the statute of limitations for a long time, and that premarital agreements, because of the nature of when an injury might arise, means that statute of limitations is tolled for a long time. So it's definitely the read it and weep case of 2021. That's what I'll say about Knapp and Ginsburg. As for O'Shea and Lindenberg, this is also interesting in the context of malpractice, though it highlights one of the issues that comes up in what might be construed as quote unquote complex financial issues for purposes of child and spousal support, and whether you should or you shouldn't advise a client to have a forensic accountant. And I think that O'Shea and Lindenberg in some ways identifies that, at least for the case of a jury in the trial court, the jury found that not advising a client to get a forensic accountant, not just in orally, but in writing, because the attorney in this case claimed that it was advised orally and that the client said no, but without doing that, a jury found that to be a breach of the standard of care. I think that's an interesting thing to consider, especially in what would be construed as limited financial resources cases, but let's say more complex support analysis. So I think O'Shea is really interesting for that point. Next slides, next two slides, because I thought I did two.
Slide, please. Okay. Tim?
Is this mine?
Yep.
I apologize. Okay, so this is Wendt and Pullen. Give me just a second. So this was an attorney's fees case, and it was a dissolution proceeding where the Superior Court denied the husband's motion to compel the trustee of an irrevocable spendthrift trust to pay attorney's fees that was stemming from his successful motion to join the trustee as a third party, and finding that the attorney's fees could only be awarded upon a finding of bad faith by the trustee. So the holding of the case, since a party does not have to prevail or even establish a prima facie claim to get need-based attorney's fees under Section 2030 from a third party that's brought into the litigation, conditioning that type of relief on the third party's bad faith, as the family court did, was inconsistent with the statute. So the trial court applied the reasoning of a spendthrift trust case, in this case, to a request for attorney's fees brought under Section 2030. So I think the takeaway to this case here is that we should remember that California has a strong public policy of ensuring that there is a level playing field between the parties to a dissolution proceeding, which is going to be effectuated through a family code Section 2030 analysis that we're all familiar with. Is there a disparity in income? Can one party afford to pay the attorney's fees for both parties? And is an award of attorney's fees appropriate under the circumstances that are present? So in this case, it was the application of the reasoning of a spendthrift trust analysis that was the mistake, as opposed to the proper analysis, which was the 2030 analysis. Next case, please.
Okay, and the last slide is in re marriage avernt. The old adage, silence is golden, does not apply in marriage avernt. You know, I cannot tell you how many times over the past 18 years attorneys have come into the courtroom and told me, Your Honor, we worked out a complete settlement in the hallway. And I point them in the direction of the stipulation forms, and they say, we would just like to put it on the record, and we'll write it up at a later date. Well, that's fine with me, but beware, because it often leads to my favorite kind of litigation. Judge, we made an agreement. Now you tell us what we agreed on. In the Aaron case, the parties recited a settlement agreement on the record. They agreed to equally divide the community property portion of the wife's federal employee pension. And the judge inquired as to whether they were freely making their agreement. They had talked to their lawyers about it, and they all said yes. However, nobody mentioned anything about these special survivor benefits that were offered by the pension. So when the husband's lawyer drafted the judgment and included those special survivor benefits, the wife said, oh no, those were not recited as part of the deal. You're not entitled to any of those survivor benefits. So the husband said at trial that he knew nothing about any survivor benefits, that nobody mentioned it during negotiations. And the first he heard about it was when he read the judgment that his attorney had drafted. And the wife said she didn't say anything about the benefit because she didn't want her husband to have it. So it ended up that the trial court treated the benefit as an omitted asset and awarded both parties their share of the survivor benefit. And the wife appealed that. And the appeals court said that an asset will be considered omitted unless the benefit was actually litigated or divided. The mere mention of an asset or lack thereof is not controlling. Silence is not golden. The demonstrative objective intent was to divide the asset. The wife's subjective intent, if I don't mention it, I get it, cannot be relied on. Contract formation, which of course is what's behind all of these post-marital agreements. Contract formation is governed by objective manifestations, not subjective intent of any individual involved. In other words, the question is not what the wife subjectively intended by her silence, but what a reasonable person would believe the parties intended. And since the legislature has mandated that each party gets their full community share, a reasonable person would expect that any other arrangement would be clearly defined. So speak up and write it all out. All right, do we have, I know we've got a little over. Gina, do we have time for any questions?
If you judges have time for 3 minutes, sure.
Okay, let me see if we've got any questions queued up.
Yes, we have two remaining.
Okay, this is the question, is MM and FM, is it significant that the acts were subsequent to the TRO?
That was my case. I don't think we know, because in that case, the trial court just didn't allow it in. I think that the Court of Appeals talked about acts that occurred after the filing of the petition, because I would suspect that whether it was subsequent to the TRO versus subsequent to the petition, or whether it was a violation of the TRO or not, those are facts that need to be taken into account under the totality of circumstances. But there's no answer to that in MM and FM.
All right, and the last question is, does the trial court have jurisdiction to include the children as protected parties for a permanent restraining order when the original request for a restraining order did not request that the children be protected parties? Anyone?
Anyone want to weigh in? I think that's an interesting question, because the renewal doesn't trigger the same analysis of good cause. And in a sense, it's adding new relief that didn't exist in the underlying restraining order. And it also has different notice requirements and a different standard of proof. I think that adding anything should be suspect.
Is the question between the TRO and the permanent? Or
I think it was a renewal. I thought it was a renewal, no?
I think the question is, in this case, is does the trial court have jurisdiction to add protected parties to the permanent restraining order
I'm sorry.
after the TRO, but prior to the issuance?
Yes, that's correct. That is the question.
I say then yes.
Okay.
I think that it's sort of like conforming to proof if the testimony and evidence presented establishes that there is a reason to add additional protected parties and they are otherwise eligible to be added as protected parties. I think the court does have that jurisdiction, but I would certainly want to make a record as to why that was happening. Amy, what do you think?
Well, plus the court always has jurisdiction to make appropriate orders regarding the best interest and safety of the children.
Yeah, and I think we've seen all the domestic violence cases. They're getting pretty expansive with the evidence, with the claims, with a lot of things in these domestic violence cases. Anyway, thank you. What a terrific panel. I learned so much from them. And thank you, Gina and the Beverly Hills Bar. We hope to see you all very soon. Thanks so much.
Very much, Your Honors.
Okay.
Good night.
Good night, everybody. Thank you very much.